A federal judge just slammed the brakes on one of the most aggressive deportation tools the Trump administration has put into motion. And if you or someone you love has any kind of unresolved immigration matter right now, you need to understand exactly what happened, why it happened, and what it means for you starting today. Because this ruling does not just affect one person or one case. It has the potential to pause, delay, or completely reshape fast-track deportation proceedings for hundreds of thousands of people currently caught inside an enforcement system that has been moving faster than at any point in modern American immigration history. The window created by this ruling is real, but it is not permanent and it is not guaranteed. So let us talk about what you actually need to know right now. Welcome to Immigration Path USA. In a moment when social media is flooded with half-truths, political spin, and outright misinformation about what is happening in immigration courts and federal agencies, this channel exists to be your clear and reliable source. We cover the real policy, the real legal developments, and the real impact on real people. Before we go any further, I need to be completely transparent with you. I am not an attorney. Nothing in this video is legal advice, and nothing here creates an attorney-client relationship of any kind. This content is strictly for educational and news purposes. Immigration law is complex. The consequences of mistakes are severe, and your specific situation requires the personalized guidance of a licensed immigration attorney or accredited representative. Please consult one. Now, let us get into this ruling, because it matters more than most people realize. To understand why this court decision is significant, you need to understand the policy it was blocking. The Trump administration, operating through the Department of Homeland Security under Secretary Kristi Noem, has been aggressively expanding the use of expedited removal. Expedited removal is a legal mechanism that allows immigration officers to deport certain individuals without a hearing before an immigration judge. No courtroom. No opportunity to present evidence. No formal adjudication, just an administrative determination by an enforcement officer and a removal order. Historically, expedited removal was used primarily at the border and applied to individuals who had been in the country for a very short period of time, generally less than 2 weeks, and were apprehended within a limited distance of the border. What the Trump administration has done, building on executive authority that has been contested in courts for years, is dramatically expand who is subject to expedited removal and where in the country that authority can be applied. The fast-track rule that the federal judge has now blocked sought to apply expedited removal to individuals anywhere in the United States who cannot immediately prove to an officer's satisfaction that they have been in the country for more than 2 years. Think about what that means in practice. If an ICE officer stops someone and that person cannot produce documents on the spot demonstrating 2 or more years of continuous presence, they become potentially subject to removal without any judicial review. No immigration judge, no hearing, no appeal. The burden of proof, under this rule, effectively shifted to the individual in the moment of encounter, and the standard of that proof was left largely to the discretion of the officer making the stop. But here is the catch that most people are missing. The constitutional and statutory problems with this rule are significant, and that is exactly why this federal judge acted. The ruling, issued by a federal district court judge, found that the expanded expedited removal policy likely violates both the Immigration and Nationality Act and due process protections embedded in the Fifth Amendment of the United States Constitution. The judge issued a preliminary injunction, which is a court order that temporarily halts enforcement of a policy while the underlying legal challenge proceeds through the court system. A preliminary injunction is not a final ruling. It is not a permanent block. It is the court saying, this policy raises serious enough legal questions, and the potential harm to people affected is serious enough that we are going to pause it while we figure out whether it is legal. That distinction is critically important for you to understand, because the administration will appeal this ruling and the legal fight is far from over. Let us talk about who issued this ruling and what authority they are exercising. Federal district court judges are appointed to lifetime positions and have jurisdiction to review the constitutionality and statutory legality of executive branch policies. When a judge issues a nationwide preliminary injunction, as appears to have happened here, it means the policy is blocked across the entire country, not just in the jurisdiction where the case was filed. The Trump administration has a pattern of challenging nationwide injunctions, arguing that district court judges should not have the authority to block policy implementation across the entire country. That argument has had mixed success in the circuit courts and has been addressed but not definitively resolved by the Supreme Court. So one of the immediate next battles in this legal fight will be over the geographic scope of the injunction itself. The agencies most directly affected by this ruling are ICE, Customs, and Border Protection, and the Executive Office for Immigration Review, which is the agency that houses the immigration court system. Under the blocked rule, ICE and CBP officers were the primary executors of expedited removal decisions. The immigration courts, the EOIR, were largely bypassed by the fast-track process. Now, with the injunction in place, cases that would have been processed through expedited removal are theoretically required to go through the standard removal proceeding process, which means an immigration judge, which means the opportunity to present your case, apply for relief, and appeal adverse decisions. That is a fundamentally different legal environment for the people affected. This is where it gets critical for anyone currently in removal proceedings or at risk of enforcement. The standard removal proceeding process involves specific forms and specific timelines that you need to understand. When someone is placed in removal proceedings, they receive a notice to appear, which is the form I-862. That document initiates the formal immigration court process and lists the charges against the individual, meaning the legal basis on which the government is seeking their removal. Once you have an I-862, you have an immigration court case. You have the right to appear before an immigration judge. You have the right to present evidence and testimony. You have the right to apply for any form of relief from removal for which you may qualify, whether that is asylum, withholding of removal, cancellation of removal, adjustment of status if a visa petition is approved, or any other applicable relief. And you have the right to appeal an adverse decision to the Board of Immigration Appeals, and from there to the federal circuit courts. None of those rights exist in an expedited removal proceeding. That is the difference this injunction is protecting right now. Let me make this real with a story, because legal frameworks only become meaningful when you attach them to human lives. Consider a man named Eduardo. Eduardo has been in the United States for 11 years. He came without documentation, found work in construction, married a United States citizen named Patricia, and together they have 2 children, both born here, both American citizens. Patricia filed an I-130, a petition for alien relative, on Eduardo's behalf 3 years ago. That petition has been approved. Eduardo is waiting for his priority date to become current so he can take the next step toward permanent residence. He is not hiding. He is not a threat to anyone. He is a father, a husband, and a taxpayer who is navigating a legal process that moves at the pace of an overwhelmed bureaucracy. Under the fast-track expedited removal rule that the judge just blocked, Eduardo was potentially at risk every single time he drove to work, every time he was in a public space where an ICE officer might stop him. If he was stopped and could not immediately document 2+ years of presence to an officer's satisfaction, his approved I-130, his pending case, his family, none of that would necessarily have protected him from being placed on a fast-track removal without ever seeing a judge. The injunction does not resolve Eduardo's immigration status, but it restores his right to a hearing if he is encountered by enforcement. It restores the due process that the Constitution guarantees him. For Eduardo, for Patricia, and for their children, that is not an abstraction. That is the difference between a family staying together and a family being destroyed. Eduardo's situation is replicated in hundreds of thousands of households across this country right now. People with pending petitions, people with approved petitions waiting on visa availability, people with long-established lives and American family members, all living with the knowledge that a policy was in place that could have removed them from the country before they could say a word in a courtroom. The injunction changes that calculus, at least for now. So here is your 3-step action plan based on where things stand today. The first step is to immediately verify the current status of any pending immigration petition or application you have in the system. If you have an I-130, an I-485, an I-589 asylum application, a DACA renewal, or any other pending matter, confirm through the USCIS online case status system that your case is active and that there are no outstanding notices you have not responded to. If your address has changed and you have not filed an AR-11, the change of address form, do that immediately. Missed notices due to outdated addresses have derailed cases that had strong merit. Do not let a procedural failure undo your legal progress. The second step is to prepare and organize your physical presence documentation right now, regardless of what happens with this injunction. The legal fight over expedited removal will continue, and future administrations or future court rulings could change the landscape again. You should have organized documentation of your continuous presence in the United States covering as much of your time here as possible. This includes tax returns, employment records, school enrollment records, lease agreements, utility bills, medical records, children's birth certificates, and any government correspondence. This documentation serves multiple purposes. It supports your immigration case. It protects you in any future enforcement encounter. And it is the foundation of virtually any relief application you might ever need to file. The third step is to consult with a licensed immigration attorney before taking any action based on this ruling or any other recent development. The injunction is real, but its scope, its duration, and its ultimate legal fate are all uncertain. Do not assume that the injunction means enforcement has stopped. ICE operations are continuing. Removal proceedings on cases already in the system are continuing. The injunction specifically targets the fast-track rule, not immigration enforcement broadly. An attorney can help you understand specifically how this ruling does or does not affect your individual situation, and what proactive steps you should take right now while the legal landscape is in this particular configuration. As you watch the next chapter of this legal fight unfold, here is what to track. The Department of Justice will almost certainly file an emergency appeal of this injunction, likely to the relevant Circuit Court of Appeals and potentially to the Supreme Court. The administration has shown a consistent willingness to seek emergency stays of lower court injunctions, and in some cases the Supreme Court has granted those stays. The timeline for appellate review can be days to weeks for emergency motions, and months to years for full merits review. In parallel, the underlying constitutional challenge to expedited removal will proceed in the district court, with briefing, oral arguments, and eventually a decision on the merits, meaning a ruling on whether the policy is actually legal, not just whether it should be paused. Watch for rulings from the Ninth Circuit and the Fifth Circuit in particular, as those courts have the most active immigration law dockets and their rulings often preview where the Supreme Court will ultimately land. What is happening in federal courts right now on immigration is not political theater. It is the actual legal architecture of millions of lives being contested in real time. Understanding it, following it, and acting on accurate information rather than rumors is one of the most concrete things you can do to protect yourself and the people you love. If you want accurate, fast, and reliable immigration updates, subscribe to Immigration Path USA right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It is essential.